There are 5 questions you should ask your attorney if you've been stopped for DUI. I'm going to go over those 5 questions with you now, but I'd like for you to go to our video vault and you can click on the links to these 5 different issues. The 5 questions are, number 1, should I have been stopped by the officer? This gets into whether or not the officer had reasonable, articulable suspicion to stop you for some type of traffic or criminal offense. The officer would have to, let's say a DUI, the officer would have to observe some type of traffic violation, be that speeding, be that driving too slow, more than 10 miles an hour under the speed limit, let's say running a stop sign, weaving, or even as what we're seeing now more frequently in our area, they stop people for a defective equipment charge, such as a tag light or a brake light violation. The second question is, should the officer have arrested you? Now that gets into whether the officer developed probable cause in order to arrest you. Now that's a higher standard than is required to stop you. That's higher than reasonable articulable suspicion, what's necessary to stop you. Probable cause means that the officer believes he has reasonable and trustworthy information that a particular person has committed a particular crime. And in a DUI situation, for example, he would use phase 1, phase 2, and phase 3 of the NHTSA training in order to develop probable cause to arrest you. That means he will use phase 1, his observations of you driving, phase 2, his personal interaction with you, let's say how you are able to exit the vehicle, what he sees, also what he hears if you admit that you've had something to drink. And then phase 3 would be the standardized field sobriety test and how you perform on those standardized field sobriety tests. All of this he would use in order to establish probable cause to arrest you for DUI. Question number 3 is, what did the officer read off of that little card? Well, the little card that the officer read to you in Georgia is your implied consent rights. In Georgia, if you drive on the highways of the state, then you have given your implied consent that you will take a state-administered breath, blood, or urine test if you're asked to, if you're under suspicion of driving while under the influence of alcohol or drugs. Implied consent is a little different than all the laws we've ever had in Georgia up until 1979 when it was implemented. Implied consent says that if you refuse to take the state's test, then your license can be suspended because of your refusal to take the state's test, as well as your refusal can be used against you in court. Your silence or your refusal to give evidence against yourself can be used against you. That goes against the common law in Georgia all the way up until 1979. The fourth question is, what are the 3 standardized field sobriety tests in Georgia? Well, Georgia uses the NHTSA standardized test. NHTSA is the National Highway and Traffic Safety Administration. The first test the officer should give you if you've agreed to take these tests, and what you need to know is that these field sobriety tests are voluntary. The officer's not going to tell you that. He's not going to tell you that you have an option, but he's going to ask you to take these tests. If you decide that you want to take the test, he should give the test to you in this order. The horizontal gaze nystagmus, that's where he's going to ask you to stand with your feet together, your hands by your side, tilt your head back slightly, and he's going to ask you to follow his finger, a pen, a pencil, a flashlight, a pen light, something with your eyes and with your eyes only while keeping your head still. Now the HGN is a scientific test, and I'll have additional information on the site giving you all the information you need to know about a horizontal gaze nystagmus test. The second test is the walk and turn. Everybody's seen people try to do that. That's where they're walking with their heel to toe, with their right foot in front of their left, their hands by their side. They walk down an imaginary line, or let's say the white line on the side of the road. They walk 9 steps. They turn on their front foot with a series of small steps. They return down the same line, walking heel to toe, keeping your hands by your side, looking down at your feet and counting your steps as you go. And once you start the walk and turn test, you're not supposed to stop. You don't stop walking. The third test that they give is the one-leg stand. And everybody's seen that on cops, I believe, and that's where the person stands, picks a foot, a leg, either leg, raises one foot 6 inches off the ground, keeps your foot horizontal to the ground, looks down at the foot and counts by 1,000s. Now and that's 1001, 1002, 1003. The one-leg stand test is a timed test. It is timed to 30 seconds. It doesn't matter if you count to 1020 or 1060. It doesn't matter. It's timed to 30 seconds. Now, personally, I normally advise my clients against taking the standardized field sobriety test because what you're doing is you're testifying against yourself. You're giving the officer information that he can use against you. Think about it this way. Let's say with a walk and turn. People don't normally walk heel to toe. The only people I've ever seen that walked one foot directly in front of the other like this is, say, a model on the catwalk. That's the only person I've ever seen that will walk that way. But I advise against taking the standardized field sobriety test. They are voluntary. The fifth question is, what is the preliminary breath test? What is that little box that I blew in on the side of the road? I hear this virtually every time, and that test is the preliminary breath test. It's sometimes confused by my clients as being the state's test. That's not the state's test. It is an approved field testing device. It is not the approved testing device in Georgia. The approved breath testing device in Georgia is the Intoxilizer 5000, or the new machine that the state's going to be getting in is the Intoxilizer 9000. Now, when you blow in the little box on the side of the road, that's the PBT, all right, preliminary breath test. Now, when you blow in that on the side of the road, it's going to give the officer a number. But now that number is not admissible in court. In court, the officer is only allowed to testify that the PBT result was either positive or negative for ethyl alcohol. That's all he can say. He can't give any result. Another thing that you need to know about the PBT is most likely the officer is not going to tell you what you blew. He doesn't want you to know what you blew. Let's say you blow over the limit in his PBT. Then he thinks that if he tells you, you're going to then decide, well, I blew over the limit, now I'm not going to blow in the Intoxilizer 5000. So he doesn't tell you anything. He just decides whether he's going to arrest you or not. He should have given you the PBT after you completed the 3 standardized field sobriety tests.